11.2, Citywide Minimum Wage Draft Ordinance. Charles Bryant and Michelle de Guzman. Thank you, Michelle. Oh, and before you start, Michelle, anyone who'd like to speak on this, where are they? They're over there. So if you can
Right here.
put one of these out, we'll speed up the process. Give you a chance to talk.
Good evening, Vice Mayor Davis and members of the Emeryville City Council. I'm Michelle de Guzman from the Economic Development and Housing Division. I'll be presenting tonight on a City of Emeryville minimum wage draft ordinance. I will also be presenting with Michael Gina from the City Attorney's Office. The purpose of tonight's report is to obtain comment and approval on a draft ordinance that will address issues of a citywide minimum wage, sick leave benefits, as well as other employment standards. As a result of this, the draft ordinance would be made available to the public to provide notice to affected parties of the impending legislation. Just as a brief background, there are two existing wage policies in Emeryville, Measure C and the living wage. Measure C passed in November of 2005 on a ballot initiative. It applies only to hotel employees. It relates to issues of compensation as well as workload and protection in the event of a management change. The living wage was enacted in 2006. It applies to full-time city employees. It does not apply to temporary part-time employees. And essentially anyone that has a contract with this city, so vendors, financial assistant recipients, lessees, licensees, concessionaires, franchisees. And there are certain limits associated with the size of the contract, the monetary size of the contract. The minimum hourly rate that is applied to these, and for both, it is inclusive of a health benefit, such that the actual monetary wage paid to the employee may be slightly reduced if there is a health benefit provided. So it's a total compensation number. Under Measure C, it was initially $9 an hour. Every March, it is adjusted by local CPI. It's currently, well, it will be on March 1st, $11.39 an hour. The living wage started at $11 an hour. It's adjusted annually on July 1st, and it is currently $14.03 per hour. This item has been considered by the council 3 times in the recent past. In 2006, it was considered as part of a comprehensive wage policy, including Measure C and the living wage. The citywide minimum wage was also considered at that time. The council directed staff to defer consideration of such an ordinance until Measure C and the living wage were in place in order to determine the impact as well as the administrative burden. In August 2014, an update was brought to the council to discuss the administrative burden that was related to Measure C and the implementation, the implementation of Measure C and living wage, as well as recent activity, as there's been quite a bit of activity in other jurisdictions regarding a local citywide or countywide minimum wage. In January 2015, a further update was brought to council as some additional measures passed after August 2014, notably measures in San Francisco and Oakland. At that time, staff made a recommendation for parameters for a potential draft minimum wage. That recommendation was essentially to match the initial hourly wage that's current or will be in place in Oakland in March, to do some community outreach activities, specifically to community meetings, an online survey, as well as to have a January 1st, 2016 effective date. Upon consideration of the staff report and public comment on the item, council provided direction to staff at that meeting, which was to develop a draft ordinance to base it on the Oakland initiative that passed last November, have the initial minimum wage rate be the same rate as the city's living wage rate that would be effective as of July 1st, 2015, which is estimated to be $14.42 an hour based on the CPI change on the existing wage. And that the ordinance would be effective as of July 1st. I thought I had put, but maybe I put July 2nd of this year, the 1st or the 2nd. And further, that additional community meetings and impact analyses were not needed before the development of this draft ordinance. So this ordinance comes to you from that. And that basis was that the UC Berkeley Center on Wage and Employment Dynamics has analyzed several large California cities, including Oakland, San Francisco, as well as Berkeley, that are adjacent to Emeryville, and those studies generally found that the negative effects of the increased minimum wage on employment, business operating costs, and consumer prices were modest to negligible. In addition, the staffs of those cities also conducted staff analyses of the minimum wage as well. And before I hand it to Michael to discuss the details of the draft ordinance itself, this table you've seen before, but it's been adjusted. The green line is the proposed minimum wage rate for Emeryville. And the bottom line that you see there is the state of California citywide, or sorry, the state of California minimum wage. It actually will rise again in 2016 to $10 an hour, and then some of our adjoining jurisdictions. San Francisco is the next highest. They have set increases up till 2018, and then they grow by a CPI growth factor. Oakland starts at 12.25, grows by CPI, and currently, Berkeley grows to just 2016. They don't have further growth, although they are considering in their labor commission changing that pattern thereafter, but they have not yet made any legislative action to that effect. And with that, I'll pass it to Michael.
Thank you, Michelle. Good evening, Council. I'm Michael Guina, Assistant City Attorney. For my portion of the presentation, I will walk you through the provisions of the draft ordinance, and I'll also highlight areas where staff is seeking City Council direction. So the ordinance for the Council's consideration would have an effective date starting July 1, 2015. There would be no phase-in. The proposed wage rate, minimum wage rate, would be set at $14.42. Which is the estimated rate, and it would be increased annually by CPI on July 1. Employees that would be covered by the ordinance are those who work at least 2 hours per calendar week within the city and who qualify for payment of minimum wage under state law. There would be no exception for the size or the type of employer. So regardless of how many employees the employer has or the type of employer, as in nonprofits, they would all be covered by the proposed ordinance. Regarding the accrual rate and cap, an employee would earn paid sick leave at the rate of 1 hour for every 30 hours worked, with a maximum accrual rate of 72 hours. That bank could be carried over from year to year. An employee would also be able to use up to the maximum, or would be able to use all of the accrued sick leave that he or she has earned over the course of the year, and there's no cap as to how much that employee may use on a yearly basis. The proposed ordinance also has a provision for hospitality service charges similar to the Oakland initiative, and I will go into that in a later slide. There's also a provision for to take into account Measure C, which I will also touch on in a following slide. There are provisions for implementation and enforcement, and there is a waiver provision for employees who are covered by collective bargaining agreements. So we also, in the context of this draft ordinance that we're proposing, there are two other pieces of legislation out there which we wanted to make the council aware of. One is the Oakland initiative, which the council had directed us to model the Emeryville initiative on. The other is a change in state law under AB 1522. This law provides for paid sick leave starting July 1, 2015. The highlights of the statute are there in front of you, and in the following slides, I'll show you where while the Oakland initiative and AB 1522 largely mirror each other, there are differences between the two statutes, and those were highlighted in the staff report. I'll also highlight them in the presentation. So the first area where the Oakland Initiative and AB 1522 differ are the employees that are not covered by the ordinance. The Oakland model covers employees who work at least 2 hours a week and qualify as an employee entitled to minimum wage law under California. And this is the version that we have presented in the draft ordinance for your consideration. AB 1522 carves out the 3 types of employees that are mentioned there in the bullets. Specifically, I'll draw your attention to a carve-out for providers of in-home supportive care services and employees that are employed by the airline industry. So one of the questions that we're asking council direction on is whether or not you would like the Emeryville ordinance to model the Oakland model or the AB 1522 model. The second area where we're seeking council direction is in the area of maximum hours that an employee can accrue for paid sick leave. Oakland has a distinction between small businesses, which are 10 or fewer employees, and those employees can earn up to 40 hours a year. Employees of all other businesses can earn up to 72 hours a year. AB 1522 provides that all employees can earn up to 48 hours or 6 days of paid sick leave each year, and there's no distinction between small businesses and non-small businesses. The draft ordinance for the City Council's consideration sets the maximum accruable hours at 72, regardless of the size of the employer. And so we're seeking City Council direction on where you would like to set the cap. Note that the City Council can allow for a higher cap than either Oakland or AB 1522. The next question for the Council is the number of hours that an employee may use paid sick leave per year. The Oakland model allows for has no limits, so that an employee may use the maximum amount that he or she has accrued. AB 1522 provides that an employee may use only up to 24 hours of paid sick leave each year. Note that AB 1522 allows employees to accrue up to 48 hours a year, but they can only use up to 24 hours a year. In the absence of any provision in the Emeryville ordinance, the provisions of AB 1522 would apply, and that would be at the 24-hour cap. The ordinance that we have presented for the Council's consideration in the Emeryville draft has no limits, like the Oakland model. An employee may use up to the maximum accrued amount. And again, we are asking for Council direction on that issue. Use of paid sick leave. The AB 1522 allows for an employee to take paid sick leave for the care of the employee or the employee's family member. And the definition of the family member is there on the slide. The Oakland ordinance adopts the AB 1522 definition of family member, but also adds that an employee may designate an individual to also take paid sick leave in order to provide care for if that employee has no spouse or domestic partner. The employee may change the designation of that individual on an annual basis. The draft ordinance that we've presented to you follows the Oakland model and allows for a designation of an individual. The start of paid sick leave. Both AB 1522 and the Oakland model allow for the use of paid sick leave beginning on the 90th day of employment, and that would be the default provision absent any other changes that the City Council calls for, and we're looking for some direction on when the City Council would like the use of paid sick leave to be able to employees to be able to use their paid sick leave. Hospitality service charge. This is a provision that was in the Oakland initiative and which we've brought into the Emeryville draft as well. A service charge is a charge that's collected by a service employer, and a service employer is defined as a hotel, restaurant, or banquet facility for services provided by the employees who actually perform the service. It specifically excludes managerial employees. The draft ordinance provides that any service charges that are collected by the employer are to be paid entirely to employees who actually performed the service. Supervisors would not be allowed to take any portion of that except to the extent that the supervisor actually performed customer service for the charge that was applied. Note that hospitality service charges are independent of tips and gratuities. We had reached out to Lift Up to ask for some implementing language that they might have developed on the Oakland initiative that might have helped guide us based on their experience in Oakland. We hadn't received any of that additional information. The ordinance also requires posting and noticing. So the minimum wage will increase July 1 each year. Working off that July date, the city will publish the wage rates for that coming year to employers by April 1. The ordinance requires that the employers will notify the employees of those wage rates by May 1. Implementation. The ordinance allows the city to adopt regulations to implement and enforce the ordinance. Complaints to the city would be complaint-driven. An employee may report violations, and the city may investigate and pursue those violations and pursue remedies that are provided in the ordinance, and I'll get to those possible remedies in a moment. In addition, the employee always retains a private right of action. So the employee may pursue his or her own action for violation of the ordinance. The remedies that are available to the city would also be available to the employee, and the employee's ability to pursue a right of action would not be dependent on any investigation or enforcement that the city is undertaking. So the employee's ability to act would not be tied to whatever the city's schedule is. Regarding enforcement by the city, so the ordinance allows for 3 different tools for the city to enact or to enforce the ordinance. The first is the issuance of administrative citations and fines. There is a fine schedule that is set in the ordinance, and bullet points are there before you for various violations of the ordinance. The second tool for enforcement that the city has is the issuance of a compliance order, in which the city would issue an order to the employer to correct specified violations of the ordinance. In this case, the employer has the right to request an administrative hearing before a hearing officer. The decision of that hearing officer would be final, and there would be no further administrative review. If a party is dissatisfied with the decision of the hearing officer, the next step after that would be to file an action in Superior Court. And lastly, the city can pursue injunctive relief by filing a civil action against the employer for violation of the ordinance. Remedies that are available for violation of the ordinance include reinstatement and back payment of payment of back wages, fines at a set rate per day per employee whose rights were violated, interest on unpaid wages, reimbursement of the city's costs for enforcement, and additional fines for repeated violations in the same year. Staff recommendation. Regarding enforcement, so this has been a question. The question before the council, one of the questions that we're posing to the council is how you would like the ordinance to be enforced. And one model is to have the enforcement done by the city or the city's contractors. Another model would be to contract with a neighboring jurisdiction to have them do the enforcement for us. The staff recommendation is to have the administration and enforcement done by city staff or its contractors. Administrative citations. So you'll note that one of the, enforcement tools that I discussed earlier was the issuance of administrative citations. We currently don't have that tool in place. However, staff plans on bringing an ordinance to the City Council on May 5th, along with the first reading of this ordinance, of the minimum wage ordinance, which will allow for issuance of administrative citations. Measure C. So Michelle introduced Measure C and its history here with the city. It was adopted by the voters in 2005, and it sets minimum wage rates and labor standards for employees of large hotels. Measure C set minimum compensation rates and compensation rates for minimum compensation, minimum average compensation, and managerial employees. They were set at the time of adoption in 2005, and it increased every year, adjusted by a CPI. The current wage rates as of March 1 are listed here. In order to have those minimum compensation, minimum average compensation, and managerial employee compensation rates to track the minimum wage rate of the minimum wage ordinance, staff recommends that we amend the minimum compensation, minimum average compensation, and managerial employee rates at these rates set here, so that they will track together with the minimum wage rates yearly by CPI. Tips and reporting. So this has been a question that was raised about how to account for employees who receive tips. So a bit of background: tips are considered income to the employee and are subject to withholding requirements. The employee is required to report tip income to the employer on a monthly basis for income in tips over $20 a month. The employer, based on the information that's reported by the employee, is required to withhold and contribute those computed taxes based on that reporting. The failure to report subjects the employer and the employee to back taxes, penalties, and interest from the IRS. And so the issue that's raised is the underreporting of tips. In order to deal with that, the IRS has introduced what's called the Tip Determination and Education Program. And that consists of two programs, both of which are voluntary. The Tip Rate Determination Agreement Program and the Tip Reporting Alternative Commitment Program. The TRAC program is essentially an education program, and there the employer establishes a program for their employees to educate them on the statutory requirements of reporting tips. Fairly straightforward. The Tip Rate Determination Agreement Program is a little bit more involved. This is essentially an agreement that's entered into between the employer and the IRS. The parties specify the classifications of employees that would be covered by the agreement. And essentially what happens is that the employer and the IRS negotiate a accepted tip rate for those covered employees. For the employees that then participate in this program, the employer would use that tip rate to make the withholding calculation. And so the covered employee would no longer be obligated to report those tips to the employer on a monthly basis. What this does is it provides a certain amount of certainty. The employee would not be subject to audit by the IRS while covered by the agreement, and the IRS has some certainty in terms of receiving a more accurate reporting on the tips absent the agreement. This is not a perfect program. The IRS, the tip rate is an average, so there may be employees that may be earning more in tips above and below that average line. And also, the tip rate is based on anticipated versus actual earnings. That being said, the IRS has determined that this is better than nothing, that they are getting more accurate accounting of tip income from the employee than they would absent the program. And this is just a sheet that sort of outlines what a typical, what the a part of the agreement would look like. It's a little hard to read, but on your left you see the occupational category, which would list the various types of employees that would be covered by the program. It includes their shifts and then what the anticipated tip rate would be. Note that this tip rate determination agreement is a voluntary agreement. That is, the employer and the IRS agree to it, and they negotiate what that tip amount would be. Thereafter, the employees' participation in this program is also voluntary. And so an employee has these protections from IRS audit, but only for the period of time that the employee agrees to participate in this program. How does this apply to the proposed Emeryville ordinance? It is one possible exception that this council could consider to the payment of minimum wage. So the issue is, for your consideration, is that you have a body of employers out there who say that they are paying their employees less than the proposed minimum wage of $14.43 an hour. However, if you take into account that base wage plus tips, the employee would actually be earning at least the proposed Emeryville minimum wage, if not more. One way for the city to determine if that were to be true would be to see if the employee, for example, has participated in this program. It is one tool that we could use in order to verify that employers are actually, that employees are actually earning at least the minimum wage in the ordinance. That is the end of my presentation. I'll hand it back over to Michelle. Thank you.
Michael, before you leave, any questions for Michael before he sits down?
No.
Not right now, no.
Okay.
I'll come back at the end of this as well.
We have Michael.
We have a list of questions for you that we'll highlight. This is as a recap, so you'll see me again. Thank you.
Okay. Michael jumped the gun on my slides there. Okay. So Michael presented to you essentially on the contents of the draft ordinance and how it interacts with existing legislation. What I'm going to talk about in this section is not included in the ordinance, but in the work on this, some possible categories that might be considered for either exemption or phased implementation, essentially due to their vulnerability due to certain aspects. And there's sort of three main categories. The first category is, or rather are, businesses that have limited resources to comply, either due to their scale or their operating structure. So scale is sort of obvious from the name. Small businesses have less ability to react in terms of capital accumulation and being nimble in terms of changing their product and service pricing or accessing bridge funding. Another group that would be vulnerable to this would be nonprofits. They may need some additional time to amend grant provisions, and the typical foundation and grant funding cycles don't coincide with the anticipated effective date of July 1st, and many of them are funded at least partially for their labor costs through those type of funding sources. Another category to consider for possible exemption would be limited duration training or internship programs. These programs are not designed to support families. They're really primarily designed to provide workforce development or training, and in order to allow essentially employers or businesses to continue to provide these kind of programs, it may be a consideration to have these be considered for possible exemption. And then finally, businesses that provide compensation at or above the minimum wage other than direct payroll. The first one would be the extensive discussion Michael just had regarding employees that receive tip income, as well as as considered under our living wage model, a place where there's health care benefits provided as part of a total compensation package. This primarily relates to phased implementation rather than simple exemption. And this harkens back to the UC Berkeley studies that were referenced earlier, generally concluded that the costs of minimum wage increases are offset through increased worker productivity, retention, and minor increases in consumer prices. However, the proposed rate of $14.42 that would be in place by July 1st is significantly higher than any minimum wage rate that we certainly found in our investigations that would be in place in 2015. The 1225, as examples, the 1225 rate in Oakland is about 36% higher than the current state minimum wage, whereas the proposed Emeryville rate is 59% higher. None of the cities that were recently studied by UC Berkeley analyze an increase of this magnitude within the first year of implementation, and there again could be a potential need for additional time to absorb increased labor costs, particularly for those businesses that were referenced earlier that may be more sensitive. And one possible scenario to consider for inclusion in the draft ordinance would be breaking up the effective period over 2 6-month increments, essentially increasing it to 1225 on July 1st, 2015, which would mirror what would be in place in Oakland at the time, increasing it again 6 months later to 1350. On January 1st, and then increasing it on July 1st, 2017, so that it would meet, that should be July 1st, 2016, to meet the what would be then current. So it would essentially offset it by about a year, but it would catch up by the first year, after the first year. Next is the impacts of minimum wage ordinance as contemplated. There are two main costs related to administration would be administration and enforcement, and the estimate for Emeryville would be 1 FTE or the equivalent costs for a contract employee at about $125,000 per fiscal year, and this is inclusive of benefits, so this is salary and benefits for a full-time employee. And education and outreach materials estimated at approximately $35,000, and that's related to both production and distribution. And those costs were essentially estimated using a lot of the similar costs from what's experienced in Berkeley and Oakland. And then the issue would be also city compliance with the ordinance in terms of a fiscal impact. As noted, we have a living wage ordinance, but that actually only applies to full-time employees. Most of the unrepresented part-time employees in the community services department actually make less than the proposed $14.42 per hour. So the increased wages would result in an annual increased payroll cost of approximately $80,000 per year. Additionally, there could be issues of wage compaction for those employees that are in the same classification but at the higher end of the wage rates. They may wish to have some additional adjustment in order to offset that increase. So there could be a potential impact from those on those salary schedules as well. So the total costs for the current fiscal year would be the approximately $35,000 in education and outreach materials. That would be the sort of the first initial push to notify all businesses of the change and ensure that posting met the requirements of the ordinance. From fiscal 15-16 and ongoing would be the additional cost for administration and enforcement, as well as the additional wages and benefits over the existing baseline. And both of those would have, well, particularly the wages and benefits would have the annual adjustments for city staff based on the CPI adjustments in the living wage. The anticipated costs, the total costs of $240,000 are currently unbudgeted. So the actions that would be ultimately necessary in order to bring those about would be amending the current operating budget to allocate the $35,000 from the general fund reserve balance for the education and outreach materials, and then for the mid-cycle adjustment, there would be an amendment into that budget for the implementation and enforcement costs of $205,000. The proposed timeline for implementing the ordinance based on the direction from council to have the ordinance be effective by July 1st is presented here. I'll run through it. Obviously tonight, we're looking to the council to provide additional direction on the draft ordinance, as well as provide staff approval to distribute it to affected parties. And then when that occurs, we hope to, by the end of this month, mail the draft ordinance directly to all licensed businesses. The draft ordinance will also be posted on the website. It will be discussed at the Economic Development Advisory Committee meeting scheduled for March 4th. Either March 17 or April 1st, the staff will come to the council to provide the input, any input that we have received based on the distribution of the draft ordinance, with the public hearing for the first reading of the ordinance to occur the first meeting in May. The second meeting in May would be the second reading. The ordinance itself would be effective July 1st. It leaves staff just a little over a month to put together the various steps that are necessary for implementation, including the development of the administrative instructions, which are the real groundwork of how we would do the day-to-day implementation of it, engage staffing for administration and enforcement, as well as develop all the support materials that would be necessary for implementation. The notification posters, complaint forms, and probably set up, information for providing guidelines to anyone that's inquiring about the new ordinance. And then July 1st, the ordinance would go into effect.
Welcome back.
Yeah, Michael is back, as promised.
You have further comments, Michael?
I do. I just wanted to highlight for you the various questions that we're asking the council to provide us direction on regarding the ordinance itself. So I'll start with the definition of the employee. The question that we're posing to the council is if the council would like to adopt the narrower definition of employee under AB 1522, which carves out healthcare providers and workers in the airline industry from those that would be covered by the minimum wage ordinance. The second question is the cap that you would like to set on the number of paid sick leave hours an employee may accrue. AB 1522 allows for an employee to accrue up to 48 hours or 6 days a year. Oakland allows an employee to accrue up to 40 hours for small businesses and 72 hours for all other employers. So this is really a two-part question. Would you like to distinguish between small business employers and all other employers in setting a cap, and what would that cap be? The next question for the council is the maximum hours of usable paid sick leave. So Oakland provides no limit. That is that the employee can use up to the amount of paid sick leave he or she has accrued. The AB 1522 sets a limit of usable paid sick leave at 24 hours a year, and the draft ordinance that we provided you is based on the Oakland model with no maximum usable limit up to the accrued amount. Next item is use of paid sick leave. Would the City Council like to include or allow an employee to designate an individual for whom the employee may use paid sick leave? And finally, the start date of the use of paid sick leave. So AB 1522 and the Oakland Ordinance provide a 90-day sort of 90-day period in which the employee has to wait before actually using the accrued sick leave. The question for the council is if you would like to have that provision in the Emeryville ordinance, or if you would like to allow an employee to start using accrued sick leave immediately upon passage or the effective date of the Emeryville ordinance, or some other date. So those are the questions that we're posing to you, and Michelle has a few more.
Just a few more, and this is the last slide of our presentation. The final sort of questions direction we're looking more generally is, does the council wish to include exemptions and or phased implementation for any of the following: nonprofits, internships or training programs, small businesses, businesses in which employees receive tips, or businesses that provide healthcare benefits? Is the implementation timeline proposed by staff acceptable? And does the council have any other changes or revisions to the draft ordinance? With that, that concludes our presentation on the draft citywide minimum wage, and we are both available for questions.
Thank you, Michelle and Michael. What's the pleasure of the council? My bias is to hear from the public.
Oh, can I ask a couple of clarifying questions first? So I just wanted to, sorry if I'm surprising you, I hope I'm not. It's just for the benefit of the public when they do come up to speak. I see some small business owners in the audience, and I just want to see how we arrived at the definition of small business, both for the city and then in terms of, and I actually am not sure what the number we're talking about for the accrued paid sick leave.
So the draft ordinance that the draft ordinance for the Emeryville version has no definition for small business. The small business definition is in the Oakland Lift Up initiative, and that was set at 10 or fewer employees. That was for the purposes of setting how many hours the maximum amount of accrued sick leave that an employee can accrue per year. So in Oakland, a employee of a small business may accrue only up to 40 hours a year, and all other employees would be able to accrue up to 72. The draft ordinance that we presented for you has no distinction between small business and non-small business, and so all employees, regardless of employer size, would be able to accrue up to 72 hours.
And then if we were to consider exemptions or phasing for small businesses, is that how we came up with that 10 employees or less number? Was from
the 10 employees or less number came from the Oakland Lift Up ordinance. There are other measures of small business. The Small Business Association has a different measure. I believe it is businesses that gross $2 million or less, and there's various different organizations have different ways of defining small business.
Great, and I just invite anyone from the public, if there's anyone here who had anything to do with Lift Up, if you'd like to give any rationale for a certain number, I'd love to hear it.
That's it, Michael? Okay, Michelle. We'll start with the public